Welcome to the New York Business Leaders Podcast, presented by the Coyle Group. We interview the most interesting and influential business leaders in New York and hear their stories of success, challenges, and lessons learned while building their businesses and personal brands. New episodes drop weekly, so please be sure to subscribe to get updates on your favorite stream. Without further delay, here's your host of the New York Business Leaders Podcast, Gordon Coyle.
Welcome back to the New York Business Leaders Podcast. I'm your host, Gordon Coyle. Today, Matt Miller from the M.G. Miller IP Law firm joins me to talk about patents, IP, trademark, licensing, and a lot of other topics. But we take a deep dive into the cannabis industry relative to intellectual property rights and how different federal agencies interact or actually fail to interact with each other. As the cannabis industry continues to grow, while state and federal laws morph to accommodate that growth, there are important conversations around IP that need to take place, regardless of where a company or individual stands in the development and distribution of that product. Obviously, this will be a story that's interesting to watch as it unfolds. If you'd like to get in touch with Matt, you can visit his website, which is www.mgmiller.legal, or call his office in Manhattan at 646-603-6945, or follow the firm on social at MG Miller IP. Finally, if you have an interesting story that you'd like to tell on this podcast, please reach out and let's chat. My direct dial is 845-474-2924, or you can email me at gbcoyle@thecoylegroup. I'll have Matt's contact info and mine in the show notes. Thanks. Now, on to the show. Hey, everyone. Welcome back to the New York Business Leaders Podcast. I'm your host, Gordon Coyle, and today we've got Matt Miller from MG Miller IP Law with us. Welcome, Matt.
Hi, thanks. Glad to be here.
Glad to have you. Why don't you take a couple minutes, introduce yourself, tell us what you do, and then we can start a conversation.
Sure thing. Thanks, Gordon. So as you said, I'm Matt Miller. I run an IP firm here in Manhattan, MG Miller IP Law. While I am the founding attorney, it's not just us. We have a whole staff here, and we help folks with their intellectual property legal matters. So specifically, we do a lot of patent prosecution. So folks who have inventions and want to get patents with the patent office, there's a whole back and forth involved, and we regularly handle that. Similarly for trademarks, folks want to get a trademark on their name or logo or slogan or whatever it may be. That also requires some back and forth with the trademark office, and we regularly handle that. We also help folks with disputes. Someone's knocking off your invention, someone stole your artwork, or is knocking off your brand, or just straight up counterfeiting you. We handle a lot of that dispute work as well. And then finally, we have a growing licensing practice. So to the extent you have some IP and you don't want to commercialize it yourself, you want to have somebody else sell it, you collect a royalty, we'll help negotiate those arrangements and draft the agreements, memorializing the arrangements as well. We do other stuff too. I'd say that those are our core competencies. We're pretty involved in the cannabis industry as well. We've done IP in the cannabis industry for quite a long time. And, if I say so myself, I would call myself one of America's leaders on the intersection of cannabis and IP. I write regularly on the subject. I speak regularly on the subject. I'm giving a CLE for the New Jersey State Bar Association in about a month. I'm speaking up in Boston at NECAM, also about the intersection of cannabis and IP. And I'm the guy for that. I like to think I'm the guy at least. So, and then as a dovetail for that, for folks in New Jersey and New York, we also help them apply for licenses, right? So you want to open a dispensary or cultivation op or processing center. Those are all things that the firm is able to help with as well.
So interesting. Tell us, how does cannabis and intellectual property kind of meet? How do they cross over?
I'm so glad you asked. No, well, for a law nerd like me, it's actually fascinating, right? So I guess we'll start with federal and state, right? So patents are exclusively federal. There's no such thing as a state patent. And while there are things called state trademarks, for the most part, people want and pursue federal trademarks, which give them protection across the whole US. So, as many people know, cannabis is still a Schedule I drug under federal law. So, how does that work? How does one go about getting federal protections over something that's in violation of the Controlled Substances Act? And there's a whole wave of nuance, and I'll touch, if anyone wants to speak about it in great depth, I will gladly bore you about this stuff, or you can see some of the articles I've written. But generally speaking, patents, totally open season. The case I just find to be funny and interesting, so I'll give a quick rundown. The two parties are Juicy Whip versus Orange Bang, which I just thought was funny. And before I was even into cannabis stuff back in law school, this was one of the cases that they cover in like patent law class. I just thought it was funny because of the party names.
Yep.
It's actually interesting though. So you go to 7-Eleven or your local convenience store, and you want to order one of the, not like the 7-Eleven slushies, but one of those like mixed drinks that they have that you kind of see turning around. Mm-hmm. So those jugs that go on top of the dispensing machine are called pre-mix, right? You mix the drink beforehand and it's really great. Everyone's like, oh, this drink looks so delicious. It's very good for sales. It turns out that actually creates a far inferior beverage. So as having it slosh around all day just doesn't do much for the flavor and doesn't make it a super fresh drink. So the superior option is the post mix, where you put your cup in front and then the syrup and the water dispense simultaneously to create a really fresh and solid drink. So the invention in this lawsuit was a drink that had a fake pre-mix machine just to allure people in, but actually dispensed a post-mix drink. And now, at first blush, you're like, okay, cool. This is a great device, right? It solved a nice problem. Put another way, it's a fraud machine, right? Like it is. And that was critical to the issue of this case. They said, hey, can you get a patent on a machine that breaks the law, right? That commits fraud. And this went to the Federal Circuit, which is the Federal Court of Appeals who hears patent cases for the most part. And they said, look, the Patent Office is the innovation agency. And if someone creates something that violates one of the million other laws that exist, then so there will be some other government agency whose purview that is to enforce that stuff. Patent Office is the innovation agency, and they should only be evaluating applications based on their newness, novelty, and non-obviousness, the criteria for patentability. And so that kind of set the stage in an unintended way for cannabis. Because you take that same holding, all right, we have something that's against the law, but that's not the Patent Office's purview. And the case it's well settled law. So since 2016, there's older ones, but the big one was this weird company called the Biotech Institute. If anyone knows what they do or if they're real, like please reach out to me because they're very shadowy in reality. But what they were able to do was they were able to obtain a granted patent on a strain of cannabis, which is something that had not been done prior. They said, hey, they sequenced the plant. They said, hey, with this genotype, we expect it to have these properties, a different phenotype. But because the genotype resulted in an unexpected phenotype, that was a non-obvious improvement enough, an unexpected result enough that they were able to grant a patent on that. Now, I don't know, or I don't know anyone who knows what this company has done with that patent, but it was a really nice moment in time to say, cool, like there is an avenue here. They've greenlisted this. And, in that time, there have been hundreds, thousands, probably tens of thousands of applications that touch all manner of the cannabis industry, right? So yes, novel seed genetics are great. There's a couple of different avenues you can go. There's a thing called a plant patent that you can pursue. There's something called the Plant Variety Protection Act, or the PVPA, which is a patent-like right done by the USDA, that's a whole rabbit hole for another time, but I find it really fascinating. But like extraction techniques, right? Because you have raw plant matter, and anyone who purchases any of these products, there are gummies, there are oils, there are all kinds of other stuff. So taking cannabinoids out of the raw plant material and doing stuff with it is all chemistry. So there's all kinds of chemical processes or machines that can perform these things. All of those are patentable. There's various pharmaceutical formulations, right? I mean, it's not really a secret. There are therapeutic benefits to certain cannabinoids. That's not debatable. And people have turned that into medicine. A brief a side that I will go down just because the FDA has taken an insane position here. So CBD, the second most prevalent cannabinoid, generally speaking, in the cannabis plant, is a Schedule 1 substance. And to be Schedule 1 definitionally means no medicinal use, like no therapeutic benefit at all. There is an FDA-approved drug, it's called Epidiolex, which uses CBD to treat, I believe, seizures. So the FDA has approved this drug for medicinal use, while simultaneously the DEA has classified CBD as a Schedule 1 drug, no therapeutic use. These are simultaneously existing, and it is silly, in my opinion. I think it's poor drafting and inconsistent, and it's kind of hamstringing the industry. No, I mean, it's a growing industry, but if that was made maybe Schedule 2 or Schedule 3, right? We don't need to remove it, but to just change the schedule to be more accurate, it would pave a lot of way for like financial transactions to be relaxed and allowing like banks to handle these funds more. It would make research, like getting research dollars to study these things, a lot easier to get, and we could get some government funded studies. So I think that, I mean, this is a rabbit hole, but I think that would be really cool to see. So turning back to what we're talking about though, so like patents can really touch a lot of different aspects of the cannabis industry. And because they don't care whether it's illegal federally or not, then it's open season. So we've obtained many patents on many different areas of the cannabis industry in ways that on the plant, on plant touching, on ancillary business, it's really open season. Where there's some nuance though is like, well, how do you enforce these patents, right? Let's say I got a patent on a strain of cannabis and so is infringing it. It's exclusive federal jurisdiction. So I go to federal district court and I'm submitting evidence of what? Am I going to bring cannabis into the courthouse? Right? Like how does that work? It's a little unclear. That's more of a 200 level talk. That's actually one of the things that my CLE that I'm giving next month is going to touch on and really tease out, how does one do this? Because there are infringement suits that happen. There are things you can do, things you cannot do. And that's it's probably too much for this, but there is an option there, and getting someone who's familiar with those nuances, should you have a cannabis related patent and you want to enforce it, it'll be worth your while to get someone who's been down that road before.
So if somebody, just to kind of touch on the strain of cannabis that's grown is formulated through some I don't know how you even define it, but somebody's able to grow a strain of cannabis using some techniques. Do those occur naturally? Like, would that violate a patent?
Great question. So naturally occurring phenomena are actually like one of the three categories that one can never get a patent on.
Okay.
The example, a little overly simplistic, if I find a rock, in the jungle, I find a rock and this rock cures cancer and I don't do anything. I just try to say, hey, I invented this rock. Well, like, no, you didn't invent it. It was naturally occurring. You discovered this rock. And if you were to maybe isolate what properties of the rock cured cancer and put it in a pill, that would be fine to patent, but the actual rock itself, no. So, just like a method of growing cannabis, if it's just like putting a seed in the ground, watering it, making sure your soil's in good condition for it to grow, probably not going to happen. What you do see though, it's like truly GMO cannabis, right? So they use technology such as CRISPR, which allows you to like manually edit the DNA of the plant. That's where you see a lot of the innovation, because it's really scientific and it's cool. There are these companies that are building these huge amounts of like sequences of different varieties and strains. Like a database like that is going to have immense value, right? Because we're in this weird sandbox now where like many states, it's a gray market industry. Many states have legalized it. The official position of the federal government is say, hey, if you're in a state that has legalized this and you're not violating your state laws, we're not going to enforce the federal laws against you. And that's been even Obama, like that started in Obama. Eric Holder, the attorney general under him, started this. Even, in the Trump administration with Jeff Sessions, he tried to stop this, and then Congress was like, no, like we don't care, this is a poor use of judicial resources, we're giving you no money to pursue cannabis enforcement in the states that have legalized it.
And maybe just to simplify it, because I'm sure that a lot of people don't realize that all of these DNA combinations of a plant can be patented. let's say broccoli. I'm sure that there's industrial companies that make seeds or produce seeds for vegetables that we consume, make them less, they're more resistant to certain types of bugs or diseases and things like that. So particular types of broccoli, are those patented? Those seeds patented?
Yeah, absolutely. So the big
Okay.
player in the space is Monsanto, right? With
Right.
all their corn, their GMO corn and Roundup, because they've created like a whole system, right? You buy their fertilizer, you buy their pesticides, you buy their plants that are optimized to work with their fertilizer and to not interact with their pesticides, right? And it's created this whole ecosystem. So yeah, it's totally open season. They've been doing it forever. This is me waxing poetic a little bit, but so Monsanto, you look it up. It's the famous Supreme Court case, the Monsanto seed patent case. And so how it normally works, you buy your seeds from Monsanto, and then farmers, they plant their crops, they harvest their crop, and as part of the harvest, they collect seeds, which they use for their crop next year. That's how farming's been done in American history in perpetuity. So I am a farmer. I buy my seeds from Monsanto and I just do standard practice. Monsanto is saying, hey, you have to pay us money for the seeds that you grew from our seeds. And they're like, this is absurd. There's something called the first sale doctrine. So if I have a patented widget and I sell it to you, you selling it again is not infringement because you bought it from me, the patent holder. So the same logic, they bought the seeds from Monsanto. They paid for those seeds originally, but then they tried to get, Monsanto's trying to recoup each crop. Where this is bullshit is Justice Clarence Thomas, before he took the bench, his job was general counsel of Monsanto. And he did not recuse himself in this case.
Of course not.
It's absurd. It's like, you're telling me that you don't have a single Monsanto share after serving as he was their head general counsel, like top of the legal department. It's like actually absurd. So that was the law, and Monsanto won that case. And then very quietly, they lobbied to have that codified in law. So, right, because how do you overturn the Supreme Court? Congress can pass a law, but they passed a law solidifying this decision, and it's probably never going to change, or it's going to require a huge amount of public outcry on a very esoteric issue, which I think is unlikely. And I think, the folks at Monsanto probably know that as well. Yeah. So that's kind of how the seed stuff works. So yeah, if you had GMO broccoli and you bought the patented seeds, well, you're going to have to pay that each year, unfortunately. It's wrong. It's morally wrong.
Yeah, interesting. What other industries do you guys work in?
A bunch of different industries. So, for the patent stuff, and I'd love to actually touch on trademarks as well. I kind of got into cannabis patents, and I'd love to touch cannabis trademarks, but generally speaking, we do a lot in the artificial intelligence, machine learning space. We have quite a few clients in that, folks who are innovating in there. Like all patent attorneys, we have random folks in their garages creating all kinds of kooky stuff. That's just kind of how it goes as part of the profession. We work in some pharmaceuticals, and that's on the patent side. We do a lot of chemical stuff as well. We have some chemical engineers over here. I have my degree in chemistry. I worked in a lab for a couple of years. So, we'll do a lot of stuff there. Yeah, that's, I'd say, obviously lots of little things as well, but those are our core competencies in terms of patents. In terms of trademarks, we do a lot of work in the fashion industry, a lot of work in the cosmetic industry, because it's rampant theft goes on in this, right? You can go to Canal Street, right? How much infringement are you going to find out there? A ton. And those are for the most popular brands, right? But lots of people, especially in this digital age, they'll see somebody on social media, oh, that's a cool shirt or a cool design. And they'll just go and knock it off. A lot of the times not understanding that what they've done is like a tort or is something that is impermissible. They say, oh, I gave them credit. It's not how that works. You see that one a lot. Like, oh, I tagged them.
Attribution is not a fair exchange for cash.
No, it's not. And well, in the US, we don't even. So in Europe, there are these things called moral rights, where failure to attribute a work to someone could be a violation. But we don't even have that in the US, and not really, not in that form. So, yes, it's very ineffective for doing so. But Yeah, so on the trademark side, we'll help people get their rights, and then we do a lot of enforcement actions. Fashion, beauty, cosmetics are the big ones. We have a large modeling agency. You could look it up as a client of ours, so we'll do some work for them as well. And yeah, I'd say those are like standard industries. You probably list more on the website. My marketing person's like, man, I can't believe you didn't mention blank. But like it's all on the website if anyone would care to look.
Interesting. And when it comes to violating trademarks, how does that happen? How does the owner of that trademark find out about it? What do they do? Is it like instant litigation? Is it a lawyer's letter? Like, how does that unfold itself?
Great question. So it's a standard playbook. Typically, someone gets their rights first. So by virtue of you selling stuff, you get common law trademark rights, which they're adequate. They come with some major limitations, and really that's why people, even if they have common law rights, they want the federal registration because of the extra rights that it gives. So typically, but you need some pre-existing right, either the common law or something that you actually filed for and got. Then how do you find out about it, right? I always joke, your infringers are probably not going to notify you that you're infringing. So you got to look. The cheap way is to set up a Google alert, right? For things that are your name or similar, a couple alternative phrases, maybe, or spellings. Excuse me. The more well-capitalized companies, there are these things called watch services. So there are whole agencies, there are a number of them all around, and they will monitor the internet and certain registries if you pay them to for things that are too similar to your trademark. So you say, hey, you typically done through an attorney, but you contact one of these companies and you say, hey, I want you to search for X, Y, and Z in these places on this interval every month, every 2 weeks, every quarter, whatever it may be, annually. Annually, it's not really helpful, but some people opt for that. So then you do the watch service. And for me, like as an attorney, I just get the report. Okay, this crap. Hey, here are things you might want to consider looking into. The attorney goes and takes a look. If anything is warrants contacting them, then you go to the client. Hey, potential conflict. What would you like us to do? Then, as you said, it typically starts with a lawyer letter. Of course, you can go right to court. It's expensive, and candidly, you'll probably just piss the judge off if you made no effort to resolve it outside of court at all. I mean, that's not like a law or anything, but judges are people, and they have a lot of power in the courtroom. And even soft little things you can do to put yourself in the judge's good graces can go a really long way towards you prevailing. Shouldn't be that way. It is that way. So that's that. But yeah, you send a lawyer letter, which is basically, hey, you did this. Stop, pay us. Sometimes you look for an accounting, like, hey, give us evidence of your sales, show us your inventory levels, give us a list of your customers. That's kind of extreme, but it gets asked every now and then. And then in response to that, there's kind of like 3 categories. The first, which rarely happens, is, oh, I'm so sorry. This is an honest mistake. We'll do what you ask right away. It's awesome. Doesn't happen as much as I'd like, or very common at all. The second one is they just ignore it, and then you either have to send a second letter or just go ahead and sue them. That one is unfortunately more common than I'd like it to be, because if we send you 2 letters and then we have to sue you, the settlement is going to be unfavorable, and you could have negotiated a far better deal before we had to do the expense and process of actually going to court and kicking off the litigation. And then the third one is, they say, go pound sand, we don't infringe. And, sometimes they're right, sometimes they're not right. That's kind of like a case-by-case basis on how to do that. And then it's arguments between attorneys is typically how it goes.
And are most of these offenders domestic, or do you have to chase them overseas?
Great question. So, of course, there's lots of infringement from Asia. I think even non-lawyers would understand that stuff.
Right.
To the extent that, international enforcement, and short answer is it depends. Every country has their own different rules about, can you take a U.S. judgment and bring it over to the foreign country? There's always a way to do it, and there's usually a way to do it, but each country has different requirements for whether or not they're going to honor a foreign judgment, just like the U.S. has requirements for if we're going to honor a foreign judgment. So getting your rights enforced in the U.S. is pretty straightforward. yes, the factory might be in China, but they're probably selling their stuff through Amazon in the US and entering US commerce. So
That's what
exactly.
I was gonna say. It's very common. We get a lot of clients that are inbound. They may be a distributor, wholesaler, or they may be the inventor of the product or claim to be, and it's manufactured in China and they sell it on Amazon. So that we see that a lot. So I imagine that there's just a ton of goods that are sold on Amazon that have no US representation that are, solely coming out of China or Asia.
Yeah, no, it's true. And honestly, Amazon can be pretty difficult to deal with, right? And I mean, it's like, as a business person, I understand, right? Amazon, I think it's 30% of all sales. They make money. So the extent that even if it's an infringing good and they can avoid liability however they can, an extra month of sales is a bunch of extra money in Amazon's pocket. So they don't really want to take them down. And, but they have a fine line to walk, because their failure to take it down upon being provided like actual notice, hey, this infringes, could subject them to liability. So where do they draw the line of, oh, let's take it down and avoid the liability, with, oh, let's leave it up and continue to make money? Now, I don't know this on good fact, but I've dealt with Amazon plenty, and that's the only logical reason that I can think of for why they would push back on these infringement claims, right? If a lawyer sends you a letter on a lawyer's letterhead, right? As a licensed U.S. attorney from a legitimate law firm sends a letter, what incentive would you have to not just comply? Especially because all they do comply is they delist it and then tell the owner, hey, we've delisted your thing, here's your resolution process, right? It's not even a permanent thing. So the only possible reason I can think of is the monetary gain to Amazon for selling these infringing products. But that's my tinfoil hat.
And it may just fall under the heading of because they can.
Yep, I'd say so.
Never mind the 800-pound, the 8 trillion pound gorilla.
Yeah, right. The $8 trillion gorilla or whatever their market cap is, less than that. But
so I was interested before when you were talking about bringing a product to market. Somebody has an idea. It could be we work in the pharmaceutical and nutraceutical industries, and we see this a good bit where somebody has an idea or they've brought it to the stage where it can be commercialized, but they just don't have the resources to get the whole deal done. Can you walk us through how that works? So like you said earlier, a couple guys in their garage, a startup, it could be a technology, it could be a therapeutic, it could be anything. They get to a stage where they're like, okay, we know this works, but we just don't have $12 million to make it happen. So how does that work, and how do you as an IP lawyer interact with that client and bring that product ultimately to the market?
Yeah, absolutely. Honestly, that's a tale as old as time, right? Entering the market, especially with any kind of physical good. Yeah, it's about $20 million or so to really have a good shot. And at least the circles I run in, most folks I don't know of any folks I know have that kind of spare cash lying around just to launch on this. So what does one do? The smartest thing to do is to have an early conversation with an IP attorney, right? Even if you don't file the patent at that time, or like the decision is made to hold off or follow some sort of IP roadmap, it's really important to have that conversation early. And the reason that it's so important to have it early is a lot of times people can inadvertently lose their ability to file for a patent. So in the US, I make a public disclosure. I go to Washington Square Park and I just demonstrate my device. I don't offer it for sale. I just say, look, check out my cool device. Well, I've started a 12-month timer to file a patent. And if I don't file a patent within 12 months of that date, I lose the ability to file for a patent. Now, doing something as public as going to Washington Square Park and doing it there, it doesn't need to be that public. You can go to your local Chamber of Commerce and talk to those people. You could throw a party in your backyard. Common one is a trade show, right? You have a booth at a trade show. That's more common than some of these other things I've described. But it's really important to make sure you don't inadvertently start that clock. It is especially true if you want to enter foreign jurisdictions. So while the US offers a 12-month grace period, many jurisdictions, such as Europe, don't. There's a European patent office. I know it's not a country, but so for the EPO, it requires absolute novelty. So your first disclosure must be the filing of a patent. So again, who would know that, right? If you don't practice this thing, like you wouldn't, or it would be unlikely for someone to have this critical piece of information, right? What if you're half your market or 75%, even though you happen to be based in the US? That could have major consequences. So just an early conversation with someone who understands this stuff is going to provide a lot of clarity for how the timing of stuff that has to go. So that's like just the preliminary advice there. But in terms of, the nuts and bolts, how do we get from idea to market entry? So at some point, you'll want to file a patent, or you'll want to get some kind of IP protection early on, even if you're patent pending. Because the thing is, like, we're talking in this hypothetical, someone has a good idea, but they don't have the means to take it to market. Maybe it's more than just dollars. Maybe they don't have manufacturing expertise. Maybe they need an industrial designer to make sure it doesn't cost $1 bajillion to manufacture, right? Because there are margins to keep in mind when you're scaling up. How do you interface with these people without giving the idea? And the problem with approaching these people is they have the particular expertise to go ahead and run with it. That's why you're contacting them. So yes, you can use non-disclosure agreements or non-competes, but a lot of people won't sign them, or you forget. Lots of people don't get stuff signed when they should. People are human; it just happens. So, like, what does one do? Well, if you file a patent, you're patent pending, and people don't need to agree to that. People don't need to say, "Oh, I acknowledge your patent pending." Like, you're patent pending whether the other party wants to agree to it or not. So that's why it's really helpful. You go to a VC, I don't sign NDAs. And many of them don't, and not because they're trying to cheat you, just because they see 100 deals a day. If they signed an NDA for each one, they wouldn't be able to do anything in the future. Yeah. So patent pending is really how one goes about doing this. But put another way, a bit more abstractly, some protection to make sure the folks you talk about aren't going to run away with it. And when you're seeking investment or you're seeking people to buy into the company, they're going to say, well, why do I have to work with you? Why should I? I mean, maybe the founders are incredible, amazing people, but if I was some rich dude with expertise and I could take advantage of someone, I don't know, maybe I would. I professional hazard. I don't trust anybody anymore. No relationship is sacred. I've seen brothers and sisters, parents and children, spouses, cousins, all of them have screwed each other over in one capacity or another. So it really behooves one to take these early protections. So you file the patent, or whatever, you get some sort of IP protection, because like a lot of times a trade secret is better, right? Let's say you have a new algorithm for blank, some piece of software, something's great. Sometimes patents make sense. A lot of times they don't. And a lot of times you want to keep it a trade secret. Maybe you have a dope recipe for cookies or baklava or something. You're not getting a patent on a method of making cookies, or maybe if you're making 10,000 per hour, but like you get a machine that does that. But a recipe is exceptionally difficult, if not impossible, to get protection over. So what trade secret might be the way to go, but without an early conversation with an IP attorney, because patents and trade secrets are mutually exclusive, right? A patent, you tell the world how to make and use your invention, you get a 20-year monopoly on it. Trade secret, you keep it secret, right? And then you get the protections associated with that. So, these are all early things. So anyway, you file your IP protection, then you need to build a business plan. You need to either find investors or strategic partners, could find a factory, could find someone who knows factories or someone who can help you design it more, but it's building the team, right? What are the missing pieces of these hypothetical founders that are needed to take it to market? It's different for everyone. Do you need accounting help? Do you need legal help? Something else? I'm not sure, but building the team, getting the team under good agreements. That is the pitfall I see. And that's not even IP advice. It's just people are too trusting when they're early on and they don't get stuff in writing. Then the bad thing happens. And they're like, oh, well, can we sign this now? And they're like, no, go pound sand. Like, you should have gotten this contract when we were all on good terms. And that can lead to a lot of issues. But yeah, you find the people who are going to do it. So you just find someone to make it. Are they going to drop ship it? Do you need to have an inventory here? Who are you going to sell it? A big challenge is getting the product placed in the big box stores. You have to know someone. In my experience, maybe there's an authentic channel, but the only time I've ever seen it get done, someone knew someone who knew someone who could put it on the shelf. So, search LinkedIn, make some friends, find who is part of the decision-making process for the store that you're trying to enter, and, reach out to them and try to pitch them.
So that proves how difficult it is to bring the product to market and how many resources and people you have to know and money. But so the person said, I don't have the patience, I don't have the time, I don't have those kinds of connections. So they come to you and they say, I'd rather just license this product. So how does that work? How does somebody license it and then still bring it to market?
Oh, well, the mechanics are simple. I have a patent, I have a contract which says, hey, party X, you can use my patent rights and I'm not going to sue you, and then give me some percentage in return. And so the mechanics of that are simple. That license agreement is a lengthy document that really controls the relationship between the IP holder and the person who's actually going to sell it and take it to market. That's a lengthy, robust contract that's used for that. But the challenge that I see time and time again is getting the party who's going to license it to be interested. It's challenging to get, even if you have a granted patent, right? People try to license patent pending all the time with nothing else. That's tough. But even with the granted patent, people don't invest in patents. They invest in companies or products, right? So are you selling any? Is there a prototype? Is there a market demand for it? So if someone's willing to say, hey, I got the money for the patent and zero things else, you're going to have a very, very tough time licensing it realistically. I mean, maybe you discovered cold fusion and it's so revolutionary, I would invest in it, right? But
You're thinking
outside of that,
fusion, and I'm thinking Shark Tank.
We've had folks get, some of our clients have gotten funded on Shark Tank, but it's the same thing that Shark Tank looks for. They say, have you sold any of these? Do you have users? If I give you X amount of dollars, what are you going to do with it? Right? They don't just give money. Oh, here's $1 million. Here's $1 million to start a facility in New Mexico, or these marketing partnerships or whatever. It's tied to a specific thing. It's rarely just here's some cash. And I think that's what people don't realize is they, shows like Shark Tank make it seem so easy. Oh, I put together a nice pitch. I smile real big, and so is going to invest in my company. But I don't watch Shark Tank too often. I've seen the ones that our clients have been in just because that's cool. But they ask for traction. They ask for some showing, right? And they really like skin in the game too. If you're not willing to bet on yourself, why would someone bet on you? So it's not like you need to put in $1 million, but you can start something for 5, 10, 20K. Maybe you got friends and family. That's a common initial funding of these things. So that's the type of stuff that you need, right? If it's software that looks like 300-500 users, within the past 6-12 months or so, that's like a good rough metric to try to hit to see, hey, do I have something here? Is this worth pursuing?
So I guess what you're saying is that if you had that inventor in the garage, that they got something that was viable, they got it patented, but then they're like, I don't have, what do I do now? And they came to you.
I'd help them. It just depends. So there's a joke. You can ask a lawyer any question and they're going to say it depends, right? And it depends here. What are they missing, right? There's a whole puzzle. They have a couple pieces of the puzzle, but depending on what's missing from that is going to depend on what my recommendation is. If it's a good idea, and this is not like a service we offer, but I've been in the startup space for over a decade now. I know lots of folks, and if there's someone I can make a connection for, and I think it's good and not going to be a waste of time, I'll make the connection. And sometimes things can go from there. And a lot of time, maybe that's not putting money in my pocket, but clients are grateful that you made the connection. And then whenever there is work to do, they remember you treated them fairly and were kind and professional, and then it comes back.
Yeah, exactly. And that's a lot of the way we do business as well. It's like you just never know. And if your Rolodex can help somebody get something off the ground, that's a pretty awesome thing you can do for somebody.
Yeah, I agree.
I see they were kind of coming up on, 35, 40 minutes. Is there anything in the conversation we didn't hit that you wanted to talk about that we could add in here?
Briefly. We spoke about, I went chapter and verse about cannabis patents, but what the interesting nuance is actually cannabis trademarks. I just am a nerd and love patents, so I can get a little excited and get carried away there. But what's interesting, so just to recap, patents are carte blanche. You can get a patent on something that's federally illegal, no problem. For federal trademarks, it is a requirement that you have lawful use in commerce.
Oh,
So
interesting.
if you're selling cannabis or anything that you needed a state license for, you're not getting a trademark on it, right? Or you're lying to the trademark office if you're going to say whatever. So there are a number of techniques that can be used. People put it on clothing. Oh, I got this mark for clothing. I got sour diesel for t-shirts. Sour diesel is a popular strain of cannabis if you didn't know, or it was back in the day. So that is useless. My opinion is that is useless. And so trademarks, you look for like a similarity. So whenever federal legalization happens, because I think the wise thing to do for cannabis trademarks is, don't lie, never lie to the trademark office. That's a losing strategy. But if you can get something that is legal under federal law, let's say cannabis education services, right? It's information is not illegal under federal law. You say, hey, here's the health and wellness benefits, or here's how to grow, or whatever. That's a really common strategy. The one that I love, and it's a bit of a rocky road recently, I'll get to it in a sec, are hemp-derived CBD or any hemp-derived cannabinoids are totally open season. So there was a Farm Bill of 2016, which said, hey, hemp is defined as this, and that's not marijuana. Hemp is legal and marijuana. It was a little cumbersome, the definition, you need a lot of stuff. Then in 2018, we passed the Farm Bill of 2018, which redefined hemp from a legal standpoint. So if you have so we're going back to biology class, we have Cannabis sativa L, our genus, and then we have the marijuana species and then the hemp species within this whole thing. Hemp, it's any Cannabis sativa L plant that has less than 0.3% THC on a dry weight basis. So there are hundreds of cannabinoids, but if my hemp plant is super rich in every known cannabinoid but has low delta 9 THC, it is completely legal to sell. Any of the extracts that you can pull out of that plant are completely fine for interstate commerce, for international shipping, sales on the internet, 100% legal. The DEA has come out multiple times and said, yes, that's fine. Delta 8 derived from this stuff is okay. CBD derived from this stuff is okay. And that can be really compelling. You're not allowed to put it in food or dietary supplements because of the FDA. And this is another pain point of mine. Is the FDA, they've been sitting on their hands for years, just saying, oh, well, we're interested in making a ruling, but we haven't done it yet. But because we've identified this drug as, CBD, as a candidate for study, you're not allowed to use it until we finish our study. And then recently, within the past couple of weeks, they were just like, you know what? We can't possibly rule. We're going to kick it to Congress, but you're still not allowed to put it in food until Congress makes a law. Absolute bullshit. I'm sorry if we can't curse on this, but that's really outrageous. So anyway, if you have hemp-derived cannabinoid-rich products that are not food additives, that's really good because federal legalization will come along, and I have my trademark for hemp. Is hemp related to cannabis? I think any consumer is going to say, yes, that's adequately related. Whereas, is clothing related to cannabis? Probably not. I mean, maybe, but probably not. It would be my guess. So that's there's a lot of nuance to the trademark stuff, but like if you can have pre-existing trademark rights, whenever federal legalization happens, even if it's in 10, 20 years from now, you'll have these immensely valuable property rights if you had the foresight to scope them out and craft them in the way and then actually use them, right? Because you actually have to do it. You can't just, you can file, hey, I'm intending to do this, but you can only extend that for about 3 years. And if we don't get federal legalization in the next 3 years, then you kind of wasted your effort. So it's important to actually do the thing you file for. But it's a lot of nuance there. If anyone's listening is like trying to get their branding in the cannabis industry, like definitely consider giving us a call. I have a wealth of knowledge. I have an excellent track record, and the firm has done a lot of good work, beyond just myself there as well.
So what you're saying is if somebody's got a cannabis related product and they name it, whatever they name it, but if they develop it as a hemp product first, they can carry that name over to a THC related product in the future when it becomes approved by federal law?
That's my personal opinion on this. Yes.
Okay.
And so, and just to put a little more meat on that bone, I have reasons to hold this belief. So I talked about comparing trademarks. It's a likelihood of confusion is the standard. Your jurisdiction will be between 8 and 13 factors to go through the full analysis. But for our purposes here, we can really look at the first 2 factors. First is the similarity of the mark. Let's just say I call it Zazzy Fruit. Just a name I made up, right? But so I have Zazzy Fruit for hemp products. We'll call them hemp cigarettes, right? So that's fine, completely legal. I have my registration. I'm going to be selling hemp cigarettes under the name Zazzy Fruit, and that's great. Eventually, federal legalization will come along. Now, let's say someone beats me to the punch and they file Zazzy Fruit for cannabis, not hemp. Well, the trademark office is going to say, well, hey, this guy already has Zazzy Fruit for hemp. That's too similar, so we're going to strike it down. And then if I were to apply, when you submit your trademark applications, if you have existing registrations, you can indicate that on your application. So I say, hey, that Zazzy Fruit hemp is also me, so don't cite that against me, and that's going to pave the way for my plan. Let's take the analog of this. Let's say it's Zazzy Fruit for clothing, right? So this same situation, is the trademark examining attorney going to find clothing and cannabis cigarettes to be too similar? I don't know, but we're relying, if we go the clothing route, we're relying on this prophetic examining attorney in the future to make that determination. And I don't know how clear cut that is. I candidly don't, which is why I think the hemp products make that a lot tighter of an argument. And that's one of the things that we advise clients on and how we help them kind of scope out rights in the future, and why I don't like the clothing route.
Got it. So anybody that's in the cannabis space, and probably a lot of other industries that are kind of sitting on the fence, they need to really address their IP issues early on to protect future rights that could be very valuable, especially in the cannabis space.
Yeah, I agree, because it's one of those things that Altria hasn't really gotten into, or Philip Morris, the big companies, Pfizer, Merck. These are all people who the legalization of cannabis is going to affect their industry. So there's going to be huge players with crazy lobbying strength and all this stuff that are all going to enter in a moment's notice, right? And they're probably going to have the heads up as is coming down the pike and going to be able to get a head start on stuff. What are you going to do if Pfizer comes down and releases Zazzy Fruit for hemp cigarettes, right? Or Altria does that? You need your pre-existing trademark right? And without having your existing registration, you are in for trouble. And that's why it's so helpful, right? Because it's yes, it's helpful against actors of similar sizes, but it's really the only way that David has a chance against Goliath, should that actually come to bear.
Got it. Interesting. Cool. Matt, if anybody wanted to get in touch with you to kind of continue this conversation, how would they do that?
You can Google us, MG Miller. We rank first, I hope. If you find somebody else, let me know. We try to address that. But no, you can obviously look us up online. You can reach out to the web. You can visit our website, which has all our contact information. So it's www.mgmiller.legal. The .com is a valuation company down in Richmond. I'm just waiting for them to go out of business, and then I'll seize the .com as well. So yeah, you can go to the website. That'll be good. You could obviously give us a call, 646-603-6945. And, we'll be happy to speak with you or set up a time to chat further. And all of our social handles are MG Miller IP. We're pretty active on Instagram. And I think we're getting into TikTok as well. I have to check on that, but I believe we have that handle there as well.
Cool. That's great. Matt, thanks for being on the show. It's been a pleasure speaking with you. Very interesting stuff. A lot of stuff that, I have a little knowledge of IP because of IP insurance, but not certainly what you're talking about. And I think for a lot of people, this is interesting. And if they're affiliated or they know people that are creating, building, and experimenting, inventing, these are the kinds of ideas that they need to hear about before they kind of, shoot themselves in the foot and don't protect a future interest.
Yeah, I agree. No, Gordon, this has been great. Thank you very much for having me. I love a good soapbox, and I thank you for giving me one here to speak on today.
But you have a lot of passion around what you do, so I appreciate that.
Yes.
And in closing, if you have an interesting story like Matt's that you'd like to tell on this podcast, reach out to me. I'll have my contact info in the show notes. I'll also put Matt's info in the show notes as well, so you have it handy. And until next time, be well.
All right, thanks, Gordon.
You're welcome.
That's it for this week's episode of the New York Business Leaders Podcast. Be sure to subscribe so you don't miss next week's episode. In the meantime, find more interviews and resources at nybusinessleaders.com.